Hey there, it's Eric J. Olson with another live episode of the Managing Partners podcast. Today, I am joined by Joanne from LA. How's it going, Joanne?
I'm great. How are you?
Good. Well, it's 12:30 here for me. I know it's like the start of your day there, so I appreciate you taking the time in your morning to join us.
Certainly. Glad to
Well,
be
hey,
here.
Joanne, why don't you tell us a little bit about yourself and what your firm does?
All right. I am born and raised in Los Angeles. I am a family law attorney. My practice is devoted exclusively to family law. And by that, I mean I do litigation, mediation, and some collaborative divorce services for family law exclusively. I do not do juvenile and dependency, and I do not do adoption or surrogacy law. So it's devoted exclusively to issues related to divorce, child and spousal support or alimony, division of property, reimbursement claims, and that sort of thing in a divorce context. I also prepare cohabitation agreements for same-sex and opposite sex or non-gender identifying persons, prenups, and postnuptial agreements. I also have partial or side expertise in preparing prenuptial agreements that are multi-state and multinational, so outside the United States. And that's basically what I do. And I do a lot of counseling and mediation, like pre-divorce counseling for financial planners and investment managers, their clients, CPAs, estate planning counsel, that sort of thing.
Interesting. So, really a focus on kind of, two people coming together or going their
Coming
separate
apart.
ways, right? Yeah.
Right.
That's interesting. But I think you said not really juvenile or
No,
associated with that.
no. In California, the juvenile and dependency courts are separate and apart from the family law courts, and there is a great deal of special expertise governed primarily by the Welfare and Institutions Code as distinguished from the Family Code. So it's a special bar, and most of the people who practice, I would say most, who practice in juvenile and dependency, there's some overlap with family law, but I would say there's not that much family law. There's not that many family law attorneys who also do juvenile and dependency work, or surrogacy, or adoption. They're specialized, at least in Los Angeles, they are.
Yeah. Is that something that is unique to family or juvenile focused attorneys in California?
I'm not licensed to practice in any other state, so I can't speak to the legal practices in other jurisdictions.
Gotcha. Totally understand. That's very interesting. I recently found out that not only can you get a prenup, you can get a postnup.
Yes. Yes.
Yeah. You don't hear about those a lot.
No, but I'm doing a postnup right now for a woman. It's her second marriage. She's much wealthier than her new husband. He's coming into the marriage with a lot of debt, and she doesn't want to be responsible for his premarital debts. It's just clearer this way with a postnup as to who is responsible for what debts and obligations. So she feels more comfortable, and her only son feels more comfortable with his mother having a postnup. So, but some years ago, I did a divorce for a couple. They were in their 70s. It was each their second marriage. They had done a prenup, and then they wanted to do a postnup to amend the prenup to provide for new provisions regarding spousal support, and then they got divorced. They knew they were going to get divorced. They were courteous and civil with one another, but they wanted it very clear, and they wanted the court to honor their prenup, but also honor the postnup with regard to their modification concerning support, because he had been an attorney and then retired, and he had reduced income that sort of thing. So yeah, you can do both.
So I was kind of under the impression that a postnup could only be done for a certain amount of time after you're married, the nuptials. So
That is
whenever
not
you want.
correct. No, no.
That's okay.
No,
So
but
it's
there
really.
are definite timing requirements in California for a prenup
Hmm.
in terms of when the final document, the final draft is presented to the parties, when it's reviewed, when it's signed. So there are time requirements certainly for a prenup that do not apply to a postnup. And then there are disclosure requirements uh, applicable to both. But in California, married persons are in a fiduciary relationship. Obviously, the attorneys listening will understand what that means, but in layperson's terms, it is the highest good faith and fair dealing. So there are very strict, I would say, disclosure requirements for people who are married and entering into a postnup. They may not be quite as strict for a prenup, although you must give fairly full and reasonable disclosure of your assets and debts going into a prenup as well.
Really interesting. Well, I don't have either one of those, so I don't have personal experience with that. But that is very interesting. So it definitely sounds it's an agreement.
Yes,
And
it's a
I guess it doesn't,
contract.
and I guess it doesn't really matter. Well, I assume it doesn't matter all that much if the agreement is made before or after you're married.
Well, except that you have no leverage for a postnup.
Well, yes, agreed. Understood.
Yeah.
As long as the two parties agree.
Yes.
Yeah.
Yes.
Yeah.
Yes.
That makes a lot of sense.
Yes.
How has COVID and things like office shutdowns and limited in-person interaction, how's that affected you and your law firm in the last year?
Well, I've been working mostly from home, although I do come into the office a couple days a week. I am not fully digital. I still have snail mail that comes to my office. I still have a few clients who do not pay by credit card or wire transfer, and they send me checks, which then need to be recorded and deposited and that sort of thing. Also, I'm older, and when it comes to discovery, I prefer to be able to refer to the actual documents, hence that pile behind me on the credenza there, which is
I see
to
that.
be trashed. Yes, that's but when it comes to voluminous amounts of discovery, some people are able to look at it on a flash drive. I really like to have the actual printed out documents in front of me, because I like to go through them, and then there's stickies and notes that I put on them if I'm going to do a deposition or I'm going to follow up with special interrogatories. So it helps me. Other than that, most of my meetings have been done by Zoom. The family law courts in Los Angeles are pretty much closed. They highly discourage attorneys and litigants from coming physically to court, although you have that option. And so I've done most of my hearings by webcam or on the telephone if there's no webcam. And there's no indication as to when the courts will be, quote, fully open again. I think that the courts themselves, the judges, their court clerks, the law clerks for law and discovery, I think they really prefer not having a full courtroom, people coming in and out of the courtroom, people talking, people on their cell phones, even though they're not supposed to be, the door slamming. I think they get a lot more done. My impression is that they like it very quiet. It's very studious. There are some disadvantages for counsel coming in on webcam or telephone because of delay, but there's also the option to take matters out of the system and to have a private judge. And again, the private judges who do full trials or discovery referee work or mediation are able to meet with the clients by Zoom, and they can still do separate chat rooms and separate rooms for confidentiality, and the judge can go between the rooms. So, petitioner and counsel and respondent and counsel or their experts are all can be divided up. And so it's very, very convenient. And certainly people not driving to court, now you can hire a lawyer. Los Angeles, as you may well know, is a very large county. And so sometimes before COVID, people wanted lawyers that were local. Well, now that locality mentality is not so pervasive because you don't need to drive to the lawyer's office. You don't need to drive to court. And it's changed the practice. And certainly for mediation, people used to always say, oh, I'm not going to drive from Burbank to Long Beach or to Santa Clarita. And now it doesn't matter, because if you're operating by Zoom, it doesn't matter where you are. So it's been pretty convenient. In terms of my peers, I'm in a family law study group. A lot of the lawyers have maintained their staff and are going in rather regularly, and they have been. And then there's a couple lawyers that are all online, and they haven't been to the office at all in the past year.
So something really interesting about that, what you just talked about, is that a lot of the lawyers that we deal with, they're very focused on, well, either national level, state level, or if it's local, around like a circumference around their office. So basically the local market that they're going after has to do with around their physical proximity. But it sounds like if this trend continues with these Zoom depositions and trials and everything else that has to do with courts, the physical location won't be nearly as pertinent, which means that someone like you could actually, you're in Los Angeles, you could, I assume, reasonably advertise for work out of, say, San Francisco, even though you're not based there. Whereas in the past, say 2 years ago, you would never do that.
It would be far less likely. That's true. And in fact, I am negotiating a prenup right now for a couple, and they are planning to move from the Bay Area to Los Angeles. They're both still in the Bay Area, but I represent one of the parties to the prenup, and the other attorney is in San Francisco. So, yeah. But it's state law, so it doesn't matter. You're right. It could be in Eureka and San Diego. It doesn't matter. You're right.
But that's going to open up, I imagine, a lot more opportunities for you and for other managing partners, right? You're especially if you're at traditionally a local level. Now you can have multiple local levels within your state.
You could, but you have to keep in mind that for purposes of divorce, there is a residency requirement. And so a person who wants to file, for example, in Los Angeles County must be a resident of the state for 6 months prior to the filing and a resident of Los Angeles County for 3 months prior to the date of the filing of the petition for divorce. So the person has to live there. They can hire a lawyer, an attorney who's qualified anywhere they'd like. You're right.
Interesting. I hadn't really thought of that. So one of the things that I like to cover here are
sorry,
that could be a new business. I appreciate you continuing with the interview, although that could be a client. So thank you. So growth plans and trends. So one of the trends that we just talked about are all this Zoom interaction with the courts. It sounds like, based on what you just told me, that will probably continue at some level in the future, even after all this.
I'm sorry.
It's quite all right.
Go ahead. It would probably continue.
Probably continue even post-COVID, right? It'll continue at some level. Yeah, these virtual court interactions, if you will. What are there any other kind of trends that you've picked up on in your industry that you think are pertinent?
Yeah, I'm glad you asked that. So they're having a meeting right now with the Beverly Hills Bar Association. There's going to be a MCLA, mandatory continuing legal education. This meeting doesn't happen to be mandatory, but it's for informational purposes for the state bar in California. And I just want to read a very brief printout from the Beverly Hills Bar Association, which is one of the issues that relates to the expansion of legal practice and legal services for all areas, not just family law, in California. And the blurb says, The State Bar's Professional Working Group and Closing the Justice Gap Working Group are poised to permanently change the practice of law in California by allowing paraprofessionals to perform legal work in certain administrative and court proceedings, including potentially allowing paraprofessionals to be paid on a contingency fee basis, by allowing non-attorney ownership of law firms and fee sharing with non-attorneys. So the questions obviously that are going to be coming up and will be discussed at this webinar are, how will these changes intersect with the current regulations governing unauthorized practice of law? How does the public interest and legal aid organizations, how do they feel about these proposals? Will there be an impact on attorney state bar fees and malpractice insurance premiums? And again, what are the roles of the legislature, the governor, and the California State Supreme Court with respect to these proposed rule changes? And in general, it's been noted and reported that up to 75% of citizens in California feel or actually do not have access to legal services. And it's not just related to cost and the price of attorneys, but I think, and this relates especially to family law, there is the perception that it's a win-lose situation. And with family law, you don't want that dynamic, a win-lose, because you want there to be as much civility and cooperation for the benefit of children, especially, so that they're not made pawns to this constant battle between the parents, and that the children are not felt so divided and such divisiveness and acrimony, because this causes emotional, it adversely affects the emotional well-being of children, and it lasts for a lifetime. And so this polarized dynamic doesn't work for family law, and you want to be able to provide as much legal service as possible. And will the use of additional paraprofessionals aid in that provision for legal services for family law purposes? It's not the way, but it's a way. And how we're going to, because there's certainly low cost and free legal services for family law and other civil law purposes in California now, but there's a considerable amount of expansion that's provisionally being discussed at this point, and will certainly become to some extent law in the near or not so distant future.
Yeah, really interesting. Couple things there. Towards the end of that, you talked about the impact on kids, things like divorce and whatnot. And I've seen grown adults, 40s and 50s, that still feel the pain from those days. It's that pain never goes away. So I think that's really important to try to minimize that for kids. But also you talked about paraprofessionals and non-attorney law firm ownership. But paraprofessionals, who would be a paraprofessional? What does that mean?
Well, it's a person who doesn't have a law license, but they work closely with lawyers. Now, very big law firms and family law firms, but really big civil litigation firms have a lot of paraprofessionals working for them to work up discovery, to perhaps do basic interviews with clients. For example, in bankruptcy law firms, the paraprofessionals do a lot of the work assisting the lawyers preparing schedules, interfacing with creditors, and that sort of thing, because there's a great deal of prep work at the beginning of a bankruptcy in terms of who are the creditors, have they filed claims, what's the status of their claims, that sort of thing. And in terms of civil, there's with corporate work and minutes and record keeping or real estate transactions. Certainly for probate administration, a lot of paraprofessionals working under the supervision of attorneys do a lot of the interaction with the clients and a lot of the paperwork. For family law, they may do the preparation of simple discovery documents, preparing the petition, or interviewing the client for an income and expense declaration or a schedule of assets and debts. What I think the if I may call it pushback, maybe from the bar right now, is paraprofessionals appearing in court, because right now they do not. They're not licensed to appear in court. Only a lawyer who has passed the bar and is licensed by the state and it is current with the state bar fees is authorized to practice law in court. So I think some of the concern of the bar is, well, what are they going to be doing in court? How do they know what to do? Who's going to be training them? What happens if they don't catch an issue and they make a mistake? And so who, I can't answer those questions now. I don't know.
Well, maybe they can only work with the court systems over Zoom instead of in person. I don't think that's going to really.
I don't know. I don't think that's the solution there.
Yeah.
But
yeah, I don't think so.
Yeah.
I'm just joking.
No.
Well, cool. And we are going a little bit long, but I do want to ask about some of your growth plans. So certainly you have a lot of experience. You've provided a lot of really good information. I really enjoyed the part about the trends and what things are changing. What are your growth plans for the next couple of years, say like 5 to 10 years from now?
Well, I don't plan to be working, quite honestly, in 10 years. I plan to be retired in 10 years. In the next 2 to 5 years, I'm going to be transitioning and doing much less litigation and doing a lot more mediation and preparation of agreements, cohabitation, prenups, and postnups. So I don't want to be tied down. I want to be able to work remotely like the young people do. And if I want to have a second home or a retirement home, I'd like to be able to work from there and not be tied to a physical office in Los Angeles, or at least work out of my home. So in terms of marketing, I belong to several professional networking groups, and I find that kind of marketing strategy works especially well for me. I always say family law, like estate planning law, you are talking about the most personal matters in your life, and some of it can be embarrassing or shameful, and so assuming that you're speaking to lawyers that all have the same level of expertise, their hourly rates are probably going to be somewhat comparable. I say for family law, it's most important that you have a rapport, that the litigant, the client, has a rapport with that attorney, because that litigant, that client is going to have to talk invariably about some very, very personal things. And if the client doesn't feel comfortable disclosing those things to the lawyer, that's not the right lawyer for that client. And so I always say that the emotional rapport, even though the lawyer is not to be emotionally involved in the client's life, the client has to feel comfortable talking to the lawyer about very, very personal things. And so that's why I think that personal interaction for people who know me, who make referrals to me, they know me. And I find that still, even if it's on Zoom, it's not a personal meeting. Marketing for me is getting really to know people and how do I operate, what's my philosophy and my general personality, if I may say that.
Love it.
So, yeah.
That's great. Well, if someone wants to meet with you and find out what your personality is all about and see if you can help them, what is the best way for them to reach out to you?
They should reach out to me through my website. You can just Google my name. I also have a website. My website address is showing up there on the screen. And you can call me or email me. I'm very diligent about getting back to people. You can also find out about me on LinkedIn.
There you go. All right. Thanks so much, Joanne. And for
Thank you.
anyone else who is watching, if you're a managing partner looking to spice up your marketing with things like websites or SEO, reach out to us, Array Digital, at arraylaw.com. All right, Joanne. Thanks so much.
Thank you. Bye.
Bye bye.